I think, because like the village I live in actually just adopted relatively recently a golf cart ordinance. I know a lot of Michigan's small villages and towns are doing the same. And the thing is, these guys, like what we're talking about, they jump on a golf cart in the summer because they want to go to the corner store or whatever. And the big question is, if you had a few too many pops before you get on that golf cart and you take off across town, like through the neighborhoods and that, can you get stopped for drinking and driving? Can you get charged with an OWI? And so it's a problem that we had to deal with, relatively recently. And it was the first time for me, but I'm digging into this thing and I'm like, wow, yeah, you actually can. These people need to be careful. Hey, folks, Keith Stickley here with the Stickley Law Firm located in downtown Hillsdale, Michigan. And we are going to be talking about a unique situation that some people are going to be finding themselves in this summer, and that is drinking and driving charges. Stemming from them having too much to drink and then getting behind the wheel, not of a regular car, but of a golf cart. Those little electric scooters that everybody's running around in and not really using for golf much anymore. But I think that this is going to become a much more prevalent issue, and a lot more people are going to start being charged with drinking and driving crimes based on their use of alcohol and these golf carts or electric scooters, because so many different municipalities throughout the state are starting to pass ordinances that allow them to be operated on the public streets. Now, we'll probably make another video about where you can actually operate these things, because they're really growing in popularity. And there are some very interesting specific rules that you have to comply with. Most notably, well, one, you have to comply with whatever the local ordinance says. In other words, a village or a town can actually enact its own rules regarding who can operate and how you can operate these golf cart vehicles, and what roads you can be on. And it's important to note that for the most part, you cannot operate these things on main state roads, even if that road is going through whatever municipality says that you can use them, with a couple of small exceptions, and we'll get into those exceptions also. For instance, in the village that I live in, they actually just adopted one of these golf cart ordinances. And our specific ordinance allows us to drive a golf cart around village streets, but you cannot go out on the main state roads, on the main state highway. In our case, so we have Michigan 86 going through our village, and I think 66 goes through part of it. And so you can't operate an ORV or a golf cart like we're really talking about here on those roads unless you're crossing the road, or we happen to have a bridge right downtown that's in a river. You can actually jump on it just to cross the bridge, but then you have to immediately get off of it. But that's not really what we're focusing on today. The question came up and somebody got in trouble, not in my little village, but a village not too far away, who is now allowing golf carts on there. Can you be charged with drinking and driving if you have a BAC, a blood alcohol level of 0.08 or greater? And think about this for a second. This is going to become a common thing, because when do we usually operate these kind of electric scooters and these golf carts around these towns? Oftentimes we're doing it at night, or going to the beach, or maybe back and forth from the park. And there's this misconception that just because something is a small electric golf cart that maybe only goes 25, 30 miles an hour, that is not considered technically a motor vehicle, because you don't need to have a license plate and traditional insurance and all these things on them in most of the municipalities that have passed these ordinances allowing for their operation. So let's jump into this and go over the main 4 or 5 things that you need to know before you get behind the wheel of one of these golf cart things. And we're going to go over the implications of drinking and driving a golf cart. So to start things out, we really need to have a brief discussion on what legal framework we're operating in here, and what is the definition of a vehicle, and what is the different definition of operation. Because in Michigan, you can be charged with DUI, driving under the influence, or OWI, operating while intoxicated, for operating a golf cart or an off-road vehicle like a side-by-side, a Polaris, on any public roads, even in communities that permit their use. So under Michigan law, the term vehicle encompasses a wide range of conveyances, and most of these conveyances have to be considered somehow self-propelled in nature. So Michigan doesn't really have any sort of an issue with drinking and driving a buggy. You might have some sort of drunken, disorderly person in public, but that's a topic for another day. And I have had a funny situation that involves that. But basically, we're talking about conveyances, including golf carts and ORVs. And the Michigan Vehicle Code specifically prohibits operating a vehicle upon a highway or other place open to the general public or generally accessible to motor vehicles while under the influence of alcohol or drugs. So, just like happens in OWI and DUI cases, a lot of people have some misconceptions about what that means, and we got to clear it up just as clear for golf carts as we do for cars. What does this mean when we talk about upon a highway or other place open to the general public or generally accessible to motor vehicles? Well, a highway does not just mean like the interstate, okay, or the big state highway. It can also mean just the regular local roads going through a municipality. A place open to the general public. That basically means any sort of a path designed to host a vehicle that can drive on it to make it easier than just driving through some random field or somebody's property. And an area that's generally accessible to motor vehicles is something that comes up in a lot of DUI cases that we deal with, because an area generally accessible to motor vehicles includes parking lots. This is really, really important, even private parking lots. The general rule of thumb is if the parking lot itself is connected by a driveway or a path or some sort of improved pathway or throughway, then that is considered an area that's generally accessible to motor vehicles, and you can't operate a vehicle, be it a car, motorcycle, ORV, or golf cart, while under the influence of drugs or an illegal level of alcohol, in other words, being intoxicated, in any of those areas. So it's clear when we look at the applicability to golf carts and ORVs that the statute applies to any vehicle that's going to be operated in areas accessible to the public. And this is including local streets where golf carts or ORVs are permitted by municipal ordinance. So therefore, operating the vehicles while intoxicated on these roads completely falls under the purview of Michigan's OWI laws, where certain municipalities like where I live, may allow the operation of golf carts and ORVs on their streets. These permissions do not exempt any operator from the state OWI laws. All operators have to adhere to state laws regarding intoxicated driving, regardless of the local ordinance. Now, unlike BUI charges, in other words, boating under the influence, which we've made several videos on if you just go poke around our channel, the penalties for OWI on an ORV or a golf cart, basically a land-based conveyance, are basically the exact same as if you were charged with a DUI driving a vehicle. And if you find yourself in this situation after this video, I highly encourage you, in fact, I might put a link at the end here, to watch our videos on what happens if you're charged with a DUI in a small town. Because if you're driving a go-kart around town and you're intoxicated and you run into this issue, well, that video is going to be very applicable to you as well. But the penalties are the same. So for an OWI first, OWI second, and yes, the big one, the felony, OWI third. You can get an OWI third, a felony, that is going to have a mandatory minimum 30 days in jail, and it could put you in prison, quite frankly, for quite a long time, depending on the circumstances. That can happen. Another big question that's come up in this whole scenario that we're talking about here is whether or not Michigan's implied consent laws apply to individuals operating ORVs, off-road vehicles, and golf carts on public roads, including municipalities that allow their use by local ordinance. And now, the legal basis for this and the argument is that yes, implied consent laws also, they take effect even if you're not driving a regular vehicle, even if you're driving a golf cart. Michigan compiled laws 257625C in paragraph 1 is basically the implied consent law. And it says that a person who operates a motor vehicle upon a highway or other place open to the general public or generally accessible by motor vehicles within the state, that means your parking lot and such like we were talking about, is considered to have given consent to chemical tests. Now, a chemical test, if you've watched our other content or been paying attention, a chemical test is not the roadside PBT machine that when they want you to do the funny tests and walk funny, talk funny too sometimes. That's not that. What the chemical test is after you've been arrested, there's probable cause to arrest you. They might request that you give them a blood sample for an accurate reading, or blow into a machine, usually at the jail, sometimes at just a police station or even a hospital. But that machine is sometimes called an intoxilizer or a data master. You have to, you absolutely have to, if it's suspected that you are operating while intoxicated, you have to comply with that. And if you don't, your driving privileges will be basically suspended for an entire year. Now, this does beg the question. Some people say, well, how do we know that this is applicable to the ORVs and golf carts? And the key issue really is whether the vehicle is being operated in an area that's open to the general public or is generally accessible to motor vehicles. So even though golf carts and ORVs might be restricted from highways under normal circumstances, in other words, you are not allowed to just jump on a go-kart and run down an interstate or a state highway. Local ordinances under MCL 257, 657A and the ORV statute 324-8111-31, I believe it is, can allow them to be legally operated on streets under specific conditions. But once they are allowed on public roads, they become subject to the same legal framework as any other vehicle, and that includes the implied consent rules. And to clarify even farther, the whole golf cart phenomena, I think, is a recent phenomena. That's something that we're just now seeing popping up everywhere as they become more popular. But ORVs, like side-by-sides and four-wheelers, that kind of thing, they have been being used in this capacity in municipalities for quite a bit longer than a lot of the golf carts. And that law is actually already codified. It literally says that OWI laws as applied to ORV uses, that a person shall not operate an ORV if under the influence of alcoholic liquor or a controlled substance. And it also states that a person operating an ORV on a street, a public roadway, or a right-of-way is subject to MCL 257.625, which does include the implied consent. So ORVs are clearly within the purview of Michigan's traditional OWI laws for any vehicle like a car or a motorcycle. So bottom line, yes, the implied consent laws of Michigan completely apply when you're operating a golf cart or an ORV on public streets, even if the operation is allowed by local ordinance. And refusal to submit to the breath of the chemical test can result in the exact same consequence as with any other motor vehicle. That includes license suspensions, points, and other administration penalties. So this summer, when you're firing up that new fancy golf cart that you got, you know, the one with all the fancy lights on the side and the big fancy wheels, the golf cart that will probably never see a fairway of a golf cart course ever, just keep in mind, you can be ticketed, arrested, and even lose your driver's license for refusing the breath of the chemical test, even if you were just driving back and forth from that big old 4th of July cookout that's going to be happening in your hometown. Bottom line, if you or somebody you know get arrested for an OWI on a golf cart or an ORV, and believe me, as we've just found out, it happens, give me a call. I've been able to successfully help dozens of clients in very similar situations get through it successfully. The last thing you want to do is let a backyard beer run ruin your record. Do me a big favor. If you found this content helpful, like the video, subscribe to our channel, and click around for other content that might interest you. And if you or somebody that you care about find yourself on the wrong side of the law and dealing with potentially criminal charges, if you're looking for an attorney that's going to be aggressive, strategic, and truly has your best interest in mind, give my office a call. We're here when you need us. And our goal is always to put you in a better position than when you first came into our care. Stay safe, and we'll talk to you real soon.